can't stop the signal now.
Hey there, recruit, and welcome to Rebel Squadron's tips for fighting the broken YouTube copyright system. Now, you might not like or agree with everything that I have to say. You might not even like my channel. But make no mistake, this video is meant for every single content creator that is out there making content today. Now, first and foremost, a quick disclaimer. I am not an attorney. I am not giving you legal advice. Do not take what I say and go running willy-nilly with it. Do your own research. Develop your own first-hand experience. Take what I say with a grain of salt. This is based on my own personal experiences regarding the YouTube copyright system. Now, with that said, let's continue. This is about music-based copyright claims. I have had several copyright claims based on incorporated video game music. However, this might be useful towards other types of claims. So baby steps, one step at a time. There's a lot to learn. So don't go rushing into this headlong willy-nilly. Take your time, do your research. Hopefully this is a good jumping off point for you, regardless of whatever kind of content you might make. So let me begin with incorporated product. What is incorporated product? Incorporated product is where a standalone asset or element such as a song, a character, a 3D graphic element, etc. ad nauseum has been incorporated into a new product such as a video game, movie, television show, etc. ad nauseum. Now, the usage of this asset does depend upon the licensing agreement granting the right to sell a product within an incorporated IP or intellectual property. You cannot drop somebody else's music into your videos. That is still a no-go. There is no way around that. That is what it is. However, that does not constitute incorporated product unless you have a licensing agreement that allows you to do so. Where you can use music as an incorporated product is in something like a video game. You're streaming or making a video about a game. There is music in that video game that would typically be copyright claimed. If it is incorporated into that game, the artist no longer has a right to copyright claim that music. And here's why. That music was licensed to the video game company for use in that video game. Under that agreement, the only entity that has the right to copyright claim that music in that video game environment or setting is in fact the company that produced that game to begin with. So in terms of this incorporated video game product, the artist has in fact given up rights to make a copyright claim upon that music. As such, most video game companies have declined to make copyright claims upon their video game products, which includes the video game music incorporated into that product. To reiterate, the only entity that has the right to make a copyright claim upon music that is incorporated into a video game is the producer of that video game, not the artist of the music itself. You're like, oh, okay, Rebel, that's the boring stuff. Let's get to the good stuff. So let's say you are streaming or making a video regarding a video game, and there is music incorporated into that video game that you have not added to the stream or that video. That constitutes incorporated product. And then let's say some company, Warner Music Group, Sony Music, etc., CD Baby, for example, let's say they make a copyright claim upon that music, even though it is incorporated into that video game or any other such incorporated product. What are your options at that point? Well, first and foremost, you can dispute that claim through the YouTube copyright system. Nobody likes this system, and it is understandable as to why. It takes 30 days for the YouTube copyright system to process your claim and for the other party to respond. You lose revenue if your channel is monetized. You have to disclose personal information that you might not want to disclose otherwise. It is just a cumbersome pain in the katukas. What can I say? However, there is another option, and this is probably what you've been waiting for. You can, in fact, contact the company directly, whatever music-based company this is. Warner Music, Sony Music, CD Baby, some random entity that is making these claims on behalf of these artists. It does not matter. You have every right to contact them, engage in conversation with them regarding this false copyright claim. And here's why. Incorporated product is incorporated product, and that includes music. Incorporated video game music is an incorporated product. It is, in fact, the law. Keep in mind, I'm not an attorney. I highly recommend that you verify what I'm telling you. Or, if you ever have a copyright claim like that, contact them directly, get the information from them. They will tell you these things. These companies, this is where I got a lot of my information from. Talking to these companies directly, not from YouTube. YouTube doesn't want to give you this information. They don't like talking about it. They don't like talking about much of anything. These companies, they will provide you this information. Some of them are very compliant regarding these laws, some of them less so, and I will get into that shortly. But let me go ahead and get into my personal experiences regarding these copyright claims on incorporated video game music / product. First and foremost, you do not need an attorney to engage in these conversations. My first experience was with a company called CD Baby regarding music for Transformers War for Cybertron. I looked up their contact information and I emailed them. We talked back and forth. I learned some interesting things regarding the system. They agreed to remove the copyright claim without me having to dispute it, without me having to go through YouTube. Boom, it was gone. Just like that, lickety split. It's that easy. As far as Warner Music Group goes, they are very compliant when it comes to incorporated product, in this specific case, incorporated video game music. Every time I've contacted them, they have removed the copyright claim immediately. And within just a matter of hours, it was gone without having to go through YouTube, without having to go through the dispute system, etc. ad nauseum. Now, certain other companies, and this may not surprise you, such as Sony Music Group, they've been much more difficult to get in touch with. They are not very good at responding to emails. I have one claim that is currently going through the dispute process. Should be cleared up any day now. However, they have no leg to stand on. It is in fact incorporated video game music, and I fully expect the claim to be lifted. So some of these companies are very good about it. Some of them not so much. And it is like, pulling teeth from a, angry, hungry lion or something like that, trying to get them to remove this claim. However, make no mistake, the law is on your side in these circumstances. So what is the primary problem? Once you understand this and learn how to handle these false copyright claims regarding incorporated product, here's the primary drawback. Even if you get the claim lifted, these companies, if you are a monetized channel, they get your ad revenue. And if you are not a monetized channel, well, they get the ad revenue that should have gone to the entity that has the actual real claim on the copyright. In these cases, such as incorporated video games, these video game companies, they don't care. With very specific exceptions, they generally don't care about copyright claiming their video game products, because these videos, the content and whatnot, it is a good press for these games. So yeah, they technically they do have the right to, but they choose not to, which is why you're able to utilize their video games in your streaming, in your videos. And that includes the incorporated video game music. These companies that make these false claims, they are not entitled to your ad revenue. You can fight that if you so choose, if you have the resources. So if you want that ad revenue back, I don't know how willing these companies are to return that ad revenue. That is something I've not experienced yet. My channel is not monetized as of yet, so I've yet to cross that bridge. However, if you are in that position, you can totally at least attempt to get the ad revenue back without having to get an attorney involved. However, if they are non-compliant, then you will have to get an attorney. However, you may very well have a case to get that ad revenue returned to your pocket, with the possible caveat that if the video game company decides to get involved, the ad revenue may end up going to that video game company. However, here's the thing. Like I said, they don't like to copyright claim their video games because it's good press for them, it's good exposure, gets people hyped up about their games and whatnot. Completely understandable. So yeah, you might actually have a shot at getting that ad revenue back. This leads to another question. Why does this even happen? If the incorporated video game music, incorporated product, is not covered on a copyright claim, then why are these companies making these false claims to begin with? Well, I'm glad you asked. So here's the key. These companies, they don't watch your content. They don't go through your streams. They don't go through your videos and say, hey, wait a minute, they're using my stuff, I'm slapping a claim on them. No. That's not these companies doing this, folks. This is something you got to realize. No. I had this information confirmed from these music companies directly. YouTube copyright system is the one making these claims on behalf of these companies. These companies are not making the claims. No. YouTube is making these claims there, folks. This is something you got to realize. YouTube is making false copyright claims on your content when it comes to incorporated product. When these songs, when this music pops up through their automated system, from your video or your stream, YouTube is not confirming that these claims are valid. They're not confirming that this music is not in fact part of an incorporated product. They're slapping that claim on there willy-nilly. That makes YouTube responsible. These companies are not in fact responsible for these false claims. No. As a matter of fact, YouTube is responsible for these false copyright claims. Like I said, this is specifically in regard to incorporated music with incorporated product regarding video games. I have no experience with other such copyright claims, so I cannot vouch for how widespread this information can be applied. However, I would be surprised that this information would not have some sort of benefit to other copyright situations. Hopefully this video helped you out. Hopefully this information, shed some light on some things there for you. It's definitely illuminating and eye-opening for myself. Make no mistake, the short takeaway from this is that this constitutes theft against your channel. If your channel is monetized, YouTube is slapping these false copyright claims on your channel on behalf of these other companies that are not even making these claims, you're being robbed. Plain and simple. YouTube doesn't want you to know this. I got no idea what's going to happen to this video. It might get taken down. They might hit my channel. I have no idea. But, well, guess what? This is Rebel Squadron. Rebel is in there for a reason. You can fight this. Section 230 does not make them 100% immune. It does not give them a legal right to engage in copyright theft in any way, shape, or form. Simple fact is you can fight this. So if we as content creators band together and start, fighting back against this in mass, well, who knows what we can do. Sky's the limit. You don't know if you don't try. So hopefully you found this video useful. If you have any questions, leave a comment down below. This has been a public service announcement from Rebel Squadron. See you in the Cantina, recruit. This is Rebel Squadron now, doggy.
Can't stop the signal now.